Hello, everyone. This is Ryan Thurman with Contact Center Compliance, here today with David Kaminski from Meserly and Kramer. We're very delighted to have David rejoin us as a speaker on our webinar series. David has joined us before and given us a lot of insight into what's actually happening with the FCC and the TCPA. This is a very hot issue for a lot of our clients, and there are some existing petitions out there that I know a lot of people are trying to see what's going on, and we appreciate David joining us today. We have our webinar sponsored by Newstar, who's also going to hopefully join us when they can get a better audio connection. Our company, Contact Center Compliance, provides compliance solutions to a lot of contact centers, banks, insurance companies, hospitality industry, all across the board, and we try to provide kind of best-in-class education to our customers as well as the people that we know in the industry, just to keep things updated on a regular basis, which include compliance webinars, compliance summits. We have a compliance guide. We do scrubbing with Newstar's file and federal FTC DNC, as well as wireless ID for folks out there. So we touch a lot of this very closely. So we're eager to hear what's going on ourselves, as I know there's been some new developments and just some very interesting cases. So, David, I appreciate you joining us, and I'm going to let you take over.
Great. Hello, everyone. Thank you so much for being here. We have a lot to talk to you about. You know, the TCPA is one of these volatile statutes, and it changes all the time. The court's interpretation is constantly changing, and there is no consistency between any courts throughout the country, basically. We've got, you know, FCC issues. We've got multiple petitions out there challenging the FCC to clarify all of its rules with regard to consent dialers. The FCC has just recently come out with its own briefing on the issue of consent, sort of throwing a little wrench into that and backtracking from previous positions. So we're going to get into all that, and hopefully if we can get to some of your questions, and if we can't, those of you who are on the phone, you can reach out to me. My contact information is at the end of this PowerPoint, and I'm sure that Ryan will send you the PowerPoint afterwards. So without further ado, let's move forward. We're going to get to some issues. We've got our legal disclaimer. Again, even though this sounds like I'm giving you legal advice, and I am an attorney, unfortunately I am not your attorney, and I'm not providing advice directly to you. This is just a seminar. You can see my information there, and as again, Ryan will send you the PowerPoint. Let's just get right into the heart of it. I know that so many of you on the phone know the basics, so I'm going to go over the basics pretty quickly. Again, the TCPA, we all know that it was enacted years ago. We all know what the purpose of the TCPA was, which the FCC denies. They said it was not for telemarketing, but all industries throughout the country, and every industry is falling into purview of the statute because A, there is no exemption for any industry, basically, and basically every company and industry is falling into the purview because of dialer technology. Let's just go over the law very quickly, and I'm going to give you the nutshell. I'm not going to read what's on the screen. You're going to be able to read that later. The TCPA and the focus that we're going to get on today is almost all on cells, very, very little on landlines. And the focus is this again. The TCPA prohibits a call to a cell phone via an automatic telephone dialing system or a pre-recorded message without prior express consent. Again, that's a call to a cell phone via an automatic telephone dialing system or a pre-recorded message, and that's or a pre-recorded message without prior express consent. Basically, there is an emergency exception to make calls to cell phones, and you can make an emergency call, and you don't have to have prior express consent. And I can guarantee you that as much as I agree with all of you on the phone that it is an emergency to collect the debts that you seek to collect, that is not the type of emergency exception that the TCPA has envisioned. So let's talk about the landline side. Slightly different than cell phones. The only type of potential liability for leaving a call on a residential phone, a landline phone, is by leaving a pre-recorded voice. In other words, you could make dialer calls all day to a residential line for debt collection purposes, and you're not violating the TCPA. Yes, you could, as you heard what I said, you can use your dialers all day to call residential lines. You're not going to violate the TCPA until you leave a pre-recorded voice. But there are really strong exemptions that help on the landline side. Remember, a manually dialed call does not violate the TCPA, and all of you are saying, well, what the heck is a manually dialed call? We're going to get into that. But basically, if you're picking up your handset telephone that is on your desk and you're dialing the digits and you're making that call, and that call basically goes through your standard PBX, and although plaintiff's counsel would like to find that that potentially violates the law as well, it does not. Manually dialed telephones do not. It's only using what the courts are deeming to be automated dialing equipment, the automatic dialers under the TCPA. Again, with the residential phones, we've got the exemption for a commercial call. That exemption is pretty broad and has been interpreted by courts very broadly. And they say that if you're leaving a pre-recorded message on a landline, it doesn't have an advertisement, doesn't constitute solicitation, that is a commercial call, and you fall under that commercial call exemption that you see there. The question is this: if you're making this call and you're hitting a wrong number, do you automatically get out because it is a, quote, commercial call? Many courts say even if you call a wrong number, this commercial call exemption is so broad, and the FCC has interpreted so broadly that the FCC has not said, well, wait a minute, if you're calling wrong numbers, that doesn't fall into the purview. They said it's up to the FCC to make that decision that wrong numbers do or do not come within the purview, and so far they've spoken broadly. But if you're calling wrong numbers and leaving pre-recorded messages and someone tells you to stop calling, I would honor that immediately. Very important. TCPA, we all know it's $500 a call for what is called a negligent violation, and up to $1,500 per call for a willful violation. Willful means, it doesn't mean exactly intentional. Some courts interpret willful very broadly. Some interpret it narrowly. Some say you have to know you're violating the law. Others say that it is just the act of making the call and not knowing whether you have consent or not. That could be deemed willful. Again, there's no attorney's fees, okay? No provision for recovery of attorney's fees. It gets a little dicey when you get into class action recovery because there are ways in class actions that attorneys can backdoor their fees through what is called the common fund or a general attorney or a theory to recover their attorney's fees. And I have yet to see a TCPA class action that has actually been certified by the courts or settled on a class action basis where the attorneys are not getting their fees. Very quickly, the FCC 2008 declaratory ruling, we all know this from the FCC. The FCC, although the ACA sought to get the exemption from the FCC to say exclude the debt collection industry from the purview of the statute, you never intended to include debt collectors. And they even say in part of their ruling, this 2008 ruling, that debt collectors are not auto-dialing calls because they are not using auto-dialers to call random numbers, as do telemarketers. They nevertheless said, no, we're not going to exempt you, but we're going to give you in the credit industry this gift. We're going to say if that a creditor obtains a cell phone number on an application voluntarily by the consumer or the debtor themselves, we're going to say that is consent to call the cell phone via auto-dialed equipment under the TCPA. Again, it's the voluntarily providing that number on the application. That's why, for your purposes, getting these applications are so important, getting the underlying basis for the origin of the debt. because that gives you your proof to establish prior express consent. I know what you all are saying right now. You said, gosh, do you know how difficult that is to get from many of our clients? We don't get that. We get electronic data, some account information, and the telephone numbers, and that's about it. I get that. But that's why trying to work with your creditors and trying to get the underlying documentation will help you, because it can also help defeat class certification cases. So the FCC said in its 2008 ruling, if your creditor has the number and they obtained it voluntarily from the consumer or debtor themselves, and you are collecting on behalf of the creditor, you stand in the shoes of the creditor, and therefore you as the debt collector have prior express consent, as if the creditor were collecting on their own behalf, okay? You stand in their shoes, so you have the consent that the creditor has. Many courts have said, hey, everybody, let's just be really clear here. This is really not prior express consent as that statute says. That is really implied consent. But nevertheless, this is a gift that the FCC gave to the creditor and the credit and debt collection industry. And guess what? It's in a final ruling, and many courts are saying, hey, this is the final ruling. That final ruling of the FCC cannot be challenged except by possibly a federal court of appeal. But the lower level courts, the lower federal courts, the district courts, they cannot challenge this final ruling. We're going to talk about that soon in the Mays case. Look at the very bottom of the screen. This is what is so important here. The FCC recently issued, or rather submitted an amicus brief in this case called Nigro versus Mercantile, because the issue of consent was relevant in that case. And in short, in Nigro, the plaintiff had given his number to one of the electric departments to say, hi, you've been trying to collect from my mother-in-law. She is deceased. So if I can help you at all resolve the issues of your account, give me a call and everything. I'm here to help and, close it up and whatever you need. Well, they started calling him then on his cell phone that he did give voluntarily to collect the mother-in-law's electric company debt, utility debt. And Nigro, the amicus brief from the FCC said, wait a second, express consent should be construed narrowly. You've got to look to the purpose for which someone gave consent and then go with that. This person only gave consent to help out to resolve and get his mother-in-law's account closed and the utility account may be transferred, but not, quote, to pay her debts. And he never gave authority and never said he would pay her debts. So when they called for debt collection purposes, the FCC said that has gone too far. So that has been submitted in this second Court of Appeal case, and very important issue right now. Let's talk about the timing of consent, because that's an issue. In paragraph 10 from the FCC ruling, the FCC said if you're getting this consent, consent is only deemed given if it's given to the creditor during the transaction with regard to the debt that's owed. But let me just tell you something. That's not all the FCC said in that 2008 ruling. In that FCC 2008 ruling, they also said 3 different times that as long as the number was provided in connection with an existing debt, that's in that second paragraph there, right here. In connection with the existing debt, you're good to go. But this is interesting and problematic. In that Nigro versus Mercantile FCC amicus brief, the FCC said that the time horizon for consent, in other words, when it's given, should be limited to during the transaction that resulted in the debt owed. But in that very same amicus brief, the FCC also said, they used the words in connection with the debt owed, but then harped again during the transaction that resulted in the debt. Look, the Ninth Circuit Court of Appeal has looked at this issue previous to this Nigro brief by the FCC, their amicus brief submitted in 2014. And the Ninth Circuit at least said, wait a second, I'm looking at the FCC ruling in totality. They have said as long as the number is given in connection with a particular debt and it's given before the call in question, you're good to go. And how does that not make sense? let's just talk about it from a making sense. Does during the transaction that resulted in the debt owed mean that someone could only have given the number at the time of debt origination? Many courts have said that's not what it means. Some courts have looked at this strictly and said, yes, that is what it means, but that doesn't make sense. Let's say that someone is given their number in connection with an application for a credit card. Then a month later, they get a brand new cell phone number. The first cell phone number is terminated. And they call the company and they say, hey, creditor, here is my brand new cell phone number. You have consent to call it for any and all purposes of any kind in the world. Does that mean all of a sudden that that is not consent? Yes, it is. That's express consent. That's someone saying, here is my number. In fact, you can't be calling the old number because the old number is no longer good. And guess what? That old number at some point is going to be reassigned to a newer person from whom you don't have consent to call. I know this is getting very convoluted, but this is because this whole issue is in the air. This issue is also being raised in the 11th Circuit Court of Appeal case called Mays, M-A-I-S. We're going to talk about that. The Mays case, that very issue is being challenged, but we have to use common sense, and courts have said you have to use common sense in interpreting the TCPA, or none of it makes sense. If you can only get consent from a number that's given during the transaction that resulted in the debt owed, and if that means during origination, well then guess what? You can only get a number at one time, and if it's changed, you can never get the correct number. That makes no logical sense. During the transaction that resulted in the debt owed, if you have a credit card, that's a revolving account, and you're constantly having debt. So I believe that if you gave your number at any time during the time that the credit card is open, that is giving a number during the transaction that resulted in the debt owed. Because guess what? If you paid off your credit card, you don't have a debt. But then if you've incurred new charges, you do. It has to be interpreted logically. And believe me, there's hundreds of arguments. I'm fighting this issue right now in about 5 individual TCPA actions and many class actions as well. Let's talk about consent. Consent is creditor specific, and what I mean by that, when you're calling someone on their GM account or their Capital One account, and you would say, do we have consent to call you on your cell phone? Yes, you do. That is consent, but it's creditor specific because you are only calling them about their one debt. If you were calling them regarding multiple debts, and if you asked for permission or consent to call them for any and all accounts that you may have with them, and if they say, yes, you may use this number for any and all purposes, it's the only number I have, or words to that effect, then you've got an account. But remember, that has to be very clear. Just don't assume because you've got consent to call and you're talking to the consumer or debtor on one account that you have consent to call on every other account that they may have with other creditors. So be very careful about that. That's specific from that 2008 ruling. Let's talk about very quickly this Colanet case at the bottom. Again, this ties into that Nigro case, but had nothing to do with the Nigro case. Basically the plaintiff went into Walgreens and gave her cell phone number, and they said, hey, we need your cell phone number to make sure that when we do issue your prescription, that we're not tying you into any other person into the system or any other person that has a similar name. She said, sure, no problem. So she gave consent. Well, of course, Walgreens called when the prescription was ready and left a text message. Plaintiff then sued and said, you never had consent. The court, in its first opinion, this Colanet court, in the district court first said, oh, yes, that's absolutely true, but you gave consent, and that consent was broad, and that currently meant you had consent to be called on your cell phone when your prescription was ready, because that's the purpose for which you gave it. Then there was a motion for reconsideration filed. The court came back and said, gosh, we've really rethought this issue, and plaintiff didn't give consent to be called or texted regarding her prescriptions ready, just consent to make sure that Walgreens doesn't confuse her with any other debtor or consumer. I know that sounds crazy to you. I know it sounds like they're splitting hairs, but now it's tying into the amicus brief by the FCC itself, where they're saying that consent given has to be consent relating to the purpose for which it is given, not for any purpose in the world the moment you get the number. So I know it's a tough issue, but that's why when you get consent and you get it and you can prove it's from a credit application given to a creditor, well, that certainly includes the purpose to call them in connection with their account, in connection with their credit card, and certainly in connection with a debt. But you must be very sure of how you're getting that consent. Can consent be given directly to the debt collector? Absolutely. Orally in writing? Absolutely. Okay, and we're going to be talking about how you can get consent. So consent can be given verbally. It can be given in writing. Yes, if someone has put their telephone number, let's say, on a fraud alert on the credit bureau website and said, anybody who's going to give me credit must call me to make sure that it is me, so you probably have a basis to call that person who's given their number to the credit bureau for the fraud alert purpose. I'm getting it via website. If someone checks the number on a website, hi, do you give us permission to call you on your cell phone via automated telephone dialing equipment? Yes, and they check that and they gave their cell phone number. That is consent. Placing number on the loan application, absolutely consent. The best way to get consent. It's in writing. Does it travel with an assignment of a debt? If let's say a debt is purchased, okay? An entire portfolio is purchased and everything and all rights are purchased, then basically consent that is provided in an application would travel to the subsequent purchaser, and then their debt collector stepping into their behalf would have the right then to probably call with consent. It should travel, and most courts say that it does travel. Could some courts differ? Possibly. The question is this. Let's just say that someone had verbally given consent to a credit card company sold that debt to another. Does that consent travel to the next company? Very dicey. Maybe, maybe not. You're in a tougher argument there. Does it have to be provided by the consumer? Yes. Can it be provided by the spouse? Sure, but you can get yourself in big trouble with that. We're going to talk about that. Let's talk about what is not consent, and I'll come back to the spouse in a minute.
Hey, David, before we do that, why don't we do a quick poll with the audience, and we'll find out how people are actually obtaining consent now. Got a couple options there based on what David talked about, and just kind of get an idea from folks how they're getting consent at the current moment. So we'll just take a couple minutes to do that. And we did have a quick question that came in that's very related, which is it can consent be given when an individual enters his or her phone number on an application?
Yes, and we talked about that. If someone gives consent in a credit application, a loan application, what they're saying is, I'm giving consent to be contacted at this number for normal business purposes. Normal business purposes in connection with a credit card is basically to call regarding anything about the credit card and a debt. I don't think it includes solicitation unless there is a provision that the person agreed to in the agreements, but certainly to contact them for debt collection purposes. And I have rarely ever seen that challenged. In other words, someone giving their phone number voluntarily in connection with an application for a credit card. I have rarely seen someone, a plaintiff's attorney, argue that is not consent to call them for debt collection purposes.
Cool. Let's take a look at the results. We actually had 49% with web capture, 50%, almost as much with oral capture, and then we had 38% with voice recording, and then other 37%. Some pretty interesting stats and how people are.
Those are great results. Again, voice recordings, we're going to talk about that briefly. I think voice recording is a great way because then you have living proof. Getting something on application, terrific proof. Getting someone to sign on a website that you can document and prove that the only way that you could have gotten that is if the consumer themselves put their number on the website and agreed to be called. I think that's great because you have tangible proof, and when I get later into this conversation, in the TCPA arena, it is all about the evidence, whether you're talking about an individual claim, meaning a one-off claim, or if you're dealing with a class action. It's the evidence that's key. And we see that companies who are able to produce evidence, even in the class cert arena, have a better chance of defending these actions. So moving forward, again, what is not consent? You all know this cold. Capturing it through caller ID, absolutely not consent. Someone tells you not to call them on their cell phone number, please capture that. Have a protocol for documenting that into your either collection software or your account system, whatever it may be. That way you have a written protocol. That way the company is protecting itself. Say, hey, look, not only do we honor oral revocations not to call them, we have a procedure to document it. We block the number so it could never be called by the dialer inadvertently. Okay? Skip tracing, danger Will Robinson, danger Will Robinson. With skip tracing is a problem. You don't know from whence you get your numbers. And in the Meyer versus Portfolio case, the court suggested that this is, you have a skip tracing class. Can you prove that you had prior express consent to call any of the numbers that you skip trace? Very, very difficult for a company to prove. And when plaintiff asserts a class action, sometimes they go with this very broad class of everybody in the world that you called from the beginning to the end of time. But once they go through discovery, they'll say, gosh, I may have problems with this real proving and establishing a very broad class in the class cert arena. Well, guess what? I took discovery and I found out this person skip traced. And, well, company, do you have a skip trace list? Yes, we do. Here it is for the last 3 years, 4 years. Now you have given plaintiff basically carte blanche to say, here is my class. I understand the importance of skip tracing. I understand the importance of contacting the debtors. I get it completely, and I sympathize. Unfortunately, it is a trigger for class certification actions. Plaintiffs love these because they say, well, don't you skip trace, and don't you load those into your dialers, and you don't know if you have consent for those, do you? No, no, no. There you go. It's a real problem. So please be very, very careful with your skip tracing. If you skip trace, fine. If you load the number into your collection software, fine, but make sure it's indicated as a number that you do not have consent to call with automated equipment, and call it manually till you get the permission to do so. You get the consent. Once you get that consent, then you capture it, document it, it's there, then your dialer can pick it up, but make sure you can prove it. Okay? Let's talk about there's also an issue of what do you have to say with this consent. Do you have to say, do we have consent to call you via automated dialing system numeral 47B with software update QB56? I mean, that's crazy. They've already hung up the phone. The majority of courts have said that the knowing release of the phone number is permission to call via automated dialing equipment, because the FCC said in its rulings, what someone voluntarily gives you the number in a credit application, etc., that is express consent to call them via automated dialing equipment under the TCPA. If the FCC was saying it in the context of the TCPA, there was no reason for them to say that the voluntary providing of the number is consent, and unless they're meaning consent to call via automated dialing equipment and leaving pre-recorded messages. Is it the better practice to say via an automated telephone dialing equipment or pre-recorded message? Yes. Is it difficult to do on a phone? Yes, I get. If someone says, do we have express consent to call you on your cell phone number? Yes, you do. Do I have consent to call you on the cell phone number that you've given to us? Yes, you do. That is consent. There was, some courts are looking at the language of the statute and they interpret it, very narrowly, and they say, look, it's really express consent to call via automated telephone dialing equipment, and you have to disclose that information. The majority of courts take an opposite view, but I have to note that there is that minority view. So who's responsible for proving this consent? That's a hot topic issue. The FCC said basically when you're relying on the pass-through consent situation, that's where the debt collector is saying, hi, I don't have consent myself, but I certainly got it because I have it from the creditor, and the FCC says I step into the shoes of the creditor, and the creditor had consent. It's on the application. I'm good to go. The court said, the FCC says that's fine, but the FCC is saying you, creditor, bear the responsibility for that and any violation, and so do you, debt collector. These are tough issues. What the FCC is basically saying, we gave you this consent gift, this prior express consent gift to you, creditors, and to you, debt collectors. So unfortunately, we're going to put the onus on you to prove it in the event that there's a violation, and plaintiffs use this. In class certification, does it come out a little differently? The question is always who has the burden to prove consent and who has the burden to prove it for a class. We'll talk about that briefly later, but basically the smarter plaintiffs are going to do their job. For them to prove consent, they're going to take discovery, and they're going to ask you, give me all the backup that you have to demonstrate consent for the class during the relevant period. So that's how they're going to establish their burden, by taking discovery. So even if it falls back on the plaintiff in class cert, the way they get it is from you. That's a very difficult discovery process. Let's talk about spouses and cell phones and recent decisions. We've got the, forgive me, the 11th Circuit decision. Osorio recently said a spouse could give you or say that they had consent, or yes, you can, this is not my spouse's number, but here's the number, please call, my spouse on their cell phone. Unless the consent came from the horse's mouth, you do not know whether you do or do not have consent. And if the husband gives it on behalf of the wife, you don't know whether he has common authority to give consent. And that could be a very, very expensive battle. So it always gets back to the whole issue of get consent only from the consumer, from the debtor. Please get it from the horse's mouth, because you just don't know if you get it. Yes, you may prove it, but it may cost you $50,000 to say, I got it from the spouse and I was right at the end. It's not worth it. We talked about this Mays case and the issue of consent. Mays is on appeal to the 11th Circuit Court of Appeals, which governs the federal courts and the rulings therein in Florida, Georgia, Alabama, and I think one or two other states. And basically, that the oral argument in this case is going to be heard in September, I believe, 18th. So it's coming up quickly. When the 11th Circuit will rule after that oral argument is anyone's guess. In the Breslow case, it literally took them 1 year, from July of 2013 to July of 2014, to issue their decision, only for them to say, oh, scrap our Breslow decision. We had already issued Osorio, and it covered the same exact issues. A big embarrassment for the 11th Circuit, but we're not going there right now. Very briefly, the Mays case on appeal. In addition to everything Mays said, hey, I'm looking at this consent ruling from the FCC, the 2008 ruling, and I think it's impermissible and improper, and the FCC had no right to change the word prior express consent and give this consent gift to the debt collection industry, which is really implied consent, because they're stepping into the shoes of the creditor and getting the consent that the creditor has. How this is going to come out, we don't know, but I think that the district court is going to potentially be overruled on this issue, because I don't think the district court had the right to challenge and potentially overturn a final FCC ruling, which was that FCC 2008 ruling from where this consent gift had been given in the first place. So I think that the court's going to have there. But the court said other things there. They said, I think that the whole FCC 2008 consent ruling is limited to the retail sector creditor debt collector circumstance. The FCC never said that, and I myself have challenged this issue and won in various courts, and I've also had a face-to-face meeting with the FCC staff members in Washington, D.C. and discussed this issue, and they did not intend to limit their FCC ruling to the creditor debt collector circumstance only, meaning only retail credit sector, because this judge was saying that this certainly doesn't apply to the provision of a number in context with medical care, and the majority of courts below, as you're seeing there right here, Mitchum, Murphy, Hudson's, Chavez, they all said, look, voluntarily giving your number to a healthcare provider, these courts say falls into the purview of that 2008 FCC consent ruling. The Mays decision is very problematic. It's going to be very interesting to see how many levels and all of the issues that the that the 11th Circuit addresses. Will they only address the big issue about whether this judge had the right to challenge the FCC ruling in the first place? Will they get into the other issues, or will they just refer it back to the district court to further decide the issue? This is the problem. The FCC itself has issued an amicus brief, again, a brief in this 11th Circuit hearing, and they said that they need their decisions and their final orders to remain intact such that federal district courts can't touch them, because if they don't, they're going to have no consistency throughout the United States. They understand that a federal circuit court of appeals can challenge the rulings, but final orders by an FCC, they're saying, should not be challenged by a federal district court. So we think the federal district court will be overruled on that issue. Again, it remains to be seen what will happen with the other issues.
Hey, David, before we get into the methods here, this might be a good time to, Andy's joined us from Newstar, who's helping us sponsor the webinar today, and it might be a good time for him to tell us a little bit about how they work with the FCC and just Newstar in general. So, Andy, I don't know if you can jump on here now. Andy, are you available? Thought I unmuted his line. Maybe he had to step away.
I'm sorry, Ryan, can you hear me now?
Yeah.
Hi. Yes. First of all, thanks for everybody's attendance. We are a proud sponsor of these kinds of events and support them tremendously. Newstar is at the heart of it is a data and analytics service provider, and we are certainly the numbering experts as well. So we have several products that can help folks identify the type of telephone service, wireline or wireless, and we can also help reduce the risk of identity behind that telephone number. So those are essentially the two ways that we can help. We don't really address the consent surrounding TCPA, but we do have some solutions around the telephone type and identity. And I'll turn it back over to David for him to keep going.
Thanks, Andy.
Thank you so much. So let's just talk about how to obtain consent. We talked about it previously, but make it part of the protocol, literally with your collection calls. It's got to be part of your company's protocol that you have actually articulated in writing somewhere. This is what we do. When we get a phone number, we don't know what it is. We don't know from whence it comes. We know it's a cell phone, but we don't know if we had consent. We have a custom and practice to obtain consent, and this is how we do it. Do it on your customer service calls, your collection calls. Emails, very different. Some companies can use email and can communicate with their consumers in that regard. For debt collection industry, we know it's very difficult. We know that there's privacy, third-party disclosure issues, and of course statutory disclosures that we all have to be concerned about. So we need to look at that. U.S. mail, well, we know that's going to be limited, especially for the debt collection industry. Can certain companies send out postcards? Maybe they can. If the companies have the account statements, let's say for credit cards that they're sending to their customers, and they have the customer's cell phone number on there, and they have a provision on there that says you agree to that we have the right to call you on your account at the number that's set forth herein, that could help at least to pave the way or argue whether there is consent or not consent. Let's talk about some language, and I was looking at certain terms and conditions from one creditor recently, and I like this one. I thought this was a good sample, that they're giving consent express consent to be contacted by the company or anyone calling on its behalf for any and all purposes at any telephone number or physical or electronic address that you provide or can be reached. This is very good broad language. This includes any wireless number that you provide, and you agree that the above entities, they can contact you in any way, pre-recorded messages, artificial messages, calls via automated telephone dialing equipment, et cetera, I've even seen some broader language that literally specifies the entities that can call, such as anyone to whom we assign a debt, anyone who is collecting on our behalf, debt collectors, anyone who calls for a payment purposes. This is great language to have in creditor agreements because the creditor agreements, of course, help not only the creditors, but they help you, the debt collectors, to establish consent. And this next provision is really terrific here. The one in red. You expressly acknowledge that this consent cannot be revoked without prior written agreement or acceptance by us. Why is this important? At least the 11th Circuit and several other courts said that with regard to revocation of consent, we're going to get into that, can be oral or written, except if there are contractual agreements to the contrary. So if someone has signed a credit card application and executed it, and it says the only method in which you can revoke consent is by, in writing, sent to us at the following address, then that is a restriction on the manner in which consent can be revoked. And at least according to the 11th Circuit in Osorio and the 3rd Circuit Court of Appeals in the Gager decision, consent in those courts, they would deem that that is limited. It can only be revoked not orally but only in writing. This next provision, you agree to promptly notify us at any time your contact information changes. That's terrific language. Will a court uphold it to hold a debt collector liable in case they fail to update their information? Very questionable, and you know, that could be hit or miss, and depending on the court that you're in, if you're an extraordinarily conservative court, they may look at this language and construe it very narrowly and say yes. Other courts are going to say you're not going to bind someone and you can't, quote, make them do something that they don't want to do. So it can go both ways. But it's just a great provision to have. It can only foster and give you one more argument to make in the context of this whole consent battle. Telephone scripts. Of course, you have your telephone scripts. Make sure that they're clear and unambiguous. Make sure that you, again, like we said, maintain record of any voice recordings with give consent. Make sure that you have someone actually acknowledging consent, that they say either a yes or no, not that there's silence. At some point, silence with respect to a statement can be deemed consent, but under the TCPA, with the words express consent, you need someone to affirmatively say something. Yes, yes you may, absolutely, no problem. Getting down here to samples, do we have consent to call you at this number for any and all purposes? Great language, but does it, if someone says yes, you're good to go, but does that type of question cause you problems because it's going to invite dialogue? Is someone going to say, what do you mean for any and all purposes? Does that mean telemarketing? I don't want you calling me for that. It could cause more problems because it opens the door. It's very broad consent, but if you're going to use language like that, you may want to test it in a sampling and find out what kind of responses you're getting in return. If more than 50 or 60% are saying, what does this mean? I don't understand. Why would you call me, and for what purposes are you talking about? Then that does not work, does it? Do we have consent to call you at this number for any and all accounts? Good language. You may get a yes to that. Some companies I've seen have used language like the following. By providing your phone number, you agree that we may contact you on your accounts for servicing purposes. Very good language, but that may invite questions. What do you mean servicing purposes? I don't understand. And that could invite dialogue. Maybe keeping it simple. Do we have consent to call you at this number? Do we have consent to call you at this number for this account? That gives someone, you're not giving them the opportunity to say, well, really, for what purpose? Because you're not saying for any and all purposes, for servicing purposes, and inviting questions as to what does the company mean by servicing purposes. So think about your consent, keep it narrow, keep it simple, and document it. And again, if you are recording, this is absolutely key right here, this section right here. Oh, I'm sorry. Make sure that if you're recording, that recording warning, let's say for incoming calls, if you have a standard company incoming call recording warning, make sure it can't be bypassed by someone pressing a 0 or a 1 key or an extension of a customer representative. Make sure it's locked so that no matter what button they press, it goes through a loop again so that they're hearing that recording until they listen to the full thing. It can't be bypassed. Terrific trigger. It's going to help you not only in the TCPA arena, of course, but it's also going to help you for those states that have recording warning laws. Okay? Revocation, we talked about it briefly. We've already talked about the Geiger Third Circuit case, the Osorio 11th Circuit case. Basically, Third Circuit says oral revocation is okay under the TCPA, and we don't think there's any time limitation on that right. But they also said in the absence of contractual restriction to the contrary, plaintiffs can freely and orally vote. So that you've got to look at the contract, see what the terms are. Record keeping, keep your records for at least 4 years. That's under the TCPA, very important. And carefully document any substantive changes to any application forms or any opt-in processes that you're going to have. Just maintain your records, keep them organized. The better records you have, the better evidence you can produce is, we do have consent, we document it, here is it, we record everything, and I have at least, 20,000 recordings I can produce at a glance to show you that that's how I captured consent for these particular accounts, and here you go, court, or here you go, Mr. Plaintiff. That helps to fight the class certification risk, the evidence that you don't have consent, because you do, and you have a custom and practice and protocol, and you have the evidence to back it up. Who has standing to bring these calls? So many of you know this by now. It's basically the 11th Circuit in Osorio, the 7th Circuit in Soffit. Most courts are saying, look, the called party is the language used in the TCPA. They have the right to bring an action. Who is a called party? Most courts are saying it is the subscriber to the cell phone number. Some courts are also saying it is the regular user, because they envision that the subscriber at times may be, let's say, a parent in a family plan, but that there's 5 cell phones under that plan. The only person that is a subscriber is the parent, but that the regular user is the person that has the cell phone, maintains the cell phone, and using it. Some courts may limit standing to only the subscriber. Some courts may look at the subscriber and the regular user. Let's go on to, I know, your other favorite topic, and I know you're sick of hearing about it, and I know you keep on saying to us, because it changes literally every few weeks, what is an automatic telephone dialing system under the TCPA? Well, we all know that the statutory language required that you got to have this equipment that stores or produce numbers and that uses random or sequential number generator and then dial those numbers. It's great language because, as many of you have said, none of us are using these random or sequential number generator programs. The problem is this. Just a little below here, we've got the FCC's 2008 declaratory ruling. Yes, it's that same ruling where they gave us that really wonderful consent gift. Well, guess what? The FCC giveth and it taketh away. That's just the way they operate. And so they said, hey, you know those predictive dialers you're using, debt collection industry? Well, we're going to say that they constitute a dialer under the TCPA. And what we're really talking about is anything that has the capacity to dial without human intervention. I want to make this very clear. The FCC was not focusing on the fact that the equipment could route numbers and has predictive capability. It's the automated dialing capability of these predictive dialers that they were having the issue with. So this is the problem. Courts are looking at the TCPA definition that you see in front of you, and then the FCC's definition, which is really completely different. It has nothing to do with the TCPA. So, and they're saying, well, which one do we use? Some courts say, I can't ignore an FCC final order. I've got to follow it. So they say capacity to dial without human intervention. And sorry, company, I see that you were using your dialer in this preview mode, but the bottom line is your dialer had the capacity to dial numbers without human intervention, and capacity, unfortunately, is the key. When I met in person with the FCC on a second occasion dealing with dialers, they said, well, wait a second, we're just borrowing the word capacity from the TCPA definition itself, that word capacity right there. And I said, well, not only did you borrow the word capacity, I understand that, but then you redefined the statute in its entirety and changed it from random and sequential number generation to dialing without human intervention. Well, that's what we mean, and we have the right to make changes to the TCPA. That very issue is in question. Some courts, again, are looking at the TCPA definition to make their rulings. Some are only looking at the FCC rulings. Some are looking at both, saying, you know, I'm constrained to look at both the statutory definition and the FCC's dialer definition. Some courts are looking at the TCPA definition of itself and construing it very, very broadly. Some courts are construing it narrowly, meaning they're literally saying your system has to have this random and sequential number generator program. But let me tell you what happened in a recent case so you can get the picture here. One court said, okay, I'm going to only look at the statutory definition. And I see that it talks about equipment that has this capacity to store numbers and dial them using a random and sequential number generator. Well, the court says, company, do you have a dialer? Yes, we do. Okay. Does it have a random and sequential number generator? No, it doesn't. But you use Microsoft system in conjunction with your dialer, don't you? Yes, we do. And company, doesn't Microsoft have the ability to generate random and sequential numbers on just an Excel program? Well, I guess it does, court. And defendant can't you upload that list of numbers, that random and sequential list of numbers to your dialer, which can store those numbers, and then it can call them, right? Well, yeah, I guess it could, but what does that have to do with the statute? Sorry, you may have a dialer under the TCPA under that set of facts. I know that's bizarre. I know that's absolutely crazy, but courts are interpreting them so broadly. Look at the bottom here, Sherman versus Yahoo. Yahoo actually lost, yes, with its $10,000 an hour attorneys that they can hire, and I'm exaggerating, of course, but they lost a dialer argument here because the court said, you know what, I'm looking at the law here, and I'm looking at the case law, and I think that what it means is the statute itself means all you have to do is have the capacity. The focus has to be on whether the equipment has the capacity to store numbers and dial random and sequential numbers. The equipment itself doesn't have to generate it. It just has to be generated somewhere within all the equipment that you have. Doesn't have to be within your dialer itself. So what this court was saying, hey, anywhere within your company, if you have the ability to create a random and sequential number list and then upload that numbers to your dialer and your dialer can store them, you've got a potential dialer under the statute. We are getting so far afield of what this statute was intended to do and what it was intended to cover, but this is where they're going, and this is where the rules are going. Again, you have some courts. You have the Satterfield Court that, in the Ninth Circuit, has said that the definition of a dialer is the strict definition within the TCPA, but courts even interpreting that are interpreting it much broader than I believe the Ninth Circuit ever intended. Then you have Illinois, the Griffith case, which interpreted very broadly. They look to the FCC. Other courts look to the FCC. So other courts say, look, there's expansive definitions now of what a dialer is under the FCC, and we're bound to follow it. Huge, huge dialer problems. I know you want answers. I know many of you are looking for dialer solutions. I'm dealing with this issue in probably 20 TCPA cases I'm dealing with right now, where I'm battling the TCPA definition, I'm battling the FCC definition, I'm battling dialer alternatives that companies have used in order to avoid potentially dialing or using equipment that falls within the purview of the TCPA. It's a difficult struggle. And plaintiffs, they think that everything in the world is a dialer, but maybe possibly for your desk phone sitting on your desk. But even some plaintiffs say, well, wait a second, if you have a desk phone that you manually dial, but that dialing and the dialing of that goes through an automated dialer or a dialer that has the capacity to automatic dial, well, then we think you have an auto dialer. And one or two courts have bought that crazy argument. This points to the fact, which we're going to get to, and I know we're getting close to time, but we're going to talk about the FCC issues right now because they're so important. Class actions, very briefly, they're all over the place. Look at these numbers. $24 million for a class of 4 million. $32 million for a class of 8 million people. $1.1 million for a class of 363 million people. This is where this is going. I mean, it's crazy. We've got here 2.3 million for, I know in there was a potential class size of 76,000 people. For that small of a class, these are crazy, crazy numbers. But this is what the plaintiffs are getting. This is why we need change.
Hey, David.
Evidence of, yes.
I was going to say, let's just do a quick poll. We just talked about those numbers. I know there's the Capital One case that was like 75 million that I didn't see on there. That was the whopper that got dropped about 10 days ago. But basically,
yeah,
just want to know. Oh, it is on there.
I'm sorry, it's going forward. I went a little too far. I apologize. Let me go back.
No problem. I put the poll up there while we go back to the slides. But basically, want to know if folks out there have been targeted by some of these litigators, or if they know someone that has. Just out of curiosity, the people on the call, just to see how widespread this is getting. We're hearing about it quite a bit on our end from our customers having to deal with certain individuals, and then new ones popping up that are kind of starting up. And so we've been tracking some of these numbers for in the near future, doing kind of a litigator type scrub where we can track for the individuals or the companies that are seeding phone lists and making life miserable for a lot of these companies. So
Ryan, I can tell you that myself, I'm probably defending 15 to 20 TCPA class actions right now.
Wow.
And, these cases are battles. These cases are difficult. There are many class action strategies, many techniques that help the defense, but they're still tough cases. And there's aggressive positions to take. There are ways to try to defeat classes from strategical and procedural techniques that can help at least quash these cases from the inception. There's ways to put tremendous tension between the plaintiff and their attorneys to try to kibosh the case from the very outside. So there's many different strategies to take, and each case merits an individual look just to determine what works best for that case under the facts, under the circumstance. Again, we talked about how evidence is key, and I'm just going to move past that. I'm going to move past the class action strategies because I just want to get into the FCC issues, which are so important, and give you the 411. Again, I've had meetings, several meetings in Washington, D.C. with various of your brethren, their debt collection industry members, some very large market participant members. Some of the largest collection industries in the United States came with me to these meetings to try to talk common sense to the FCC. And as you're doing the poll, I'll just go ahead to talk about, look, the lead petition that the FCC is looking at right now is the ACA's petition for rulemaking on 4 different fronts. Yes, others have filed petitions, but most of those petitions touch on issues that the ACA has put into four little neat categories. And one of them is hey, all predictive dialers that we're using, don't deem that they're automatic telephone dialing systems. Give us a chance to fight that. It's not right because they're not all automatic telephone dialing systems, and many of them don't even meet the statutory definition. So to put into the category all predictive dialers, as they basically said in their FCC ruling, is just wrong. Capacity, that word capacity should mean present ability without modification. Now, many plaintiffs' counsel have looked at this issue and said, well, wait a second, we think that many of you are using dialers that have the present capacity to dial without human intervention under the FCC's rules, so I don't care, I won't argue theoretical capacity. They're saying I'll just argue present ability, and your dialer has that. So that's an issue because of the word capacity. But it helps to narrow the field because some courts are looking at this theoretical capacity. Well, can't you just add X software, and wouldn't that give your dialer the ability then to randomly and sequentially dial? Well, that's theoretical capacity. That is not present capacity. If the software doesn't exist in the system, that's a ludicrous argument, one that is not common sense and doesn't make sense. The furnishing of the safe harbor, that is a very strong argument. This is where you had consent, and you can demonstrate that you had consent from the outset, but that the number somehow was reassigned to a party unbeknownst to you. And therefore, you know, can we get a safe harbor for calling wrong numbers where we had consent in the first place to dial that number? The FCC is looking strongly at that issue. In fact, the commissioner, O'Reilly, the Republican commissioner, issued a public blast on March 25th, 2014 of this year and said, look, there's so many problems with this telephone, you know, this TCPA. What's a dialer under the TCPA? I understand that many of you are confused about that. What about wrong numbers? Are you responsible for recalling wrong numbers? And he went so far as to say it's a sad day when businesses have to come to the FCC to learn how to determine whether or not they can contact their customers for business purposes. So they realize that there's problems. We are hoping that at least at the very outset, they will give a safe harbor to all industry for wrong number calls when you had consent to call the number in the very first place, because you don't know to whom it's been reassigned, and many times you don't know if it's been reassigned. So that's an issue that we think that the FCC really understands. I've spoken to them about this issue, and they get it. What they're going to do, though, is a different story. On the dialer side, they get that everything in the world right now is a dialer under the current court's interpretations. One federal court said, look, you got to use common sense in interpreting what is a dialer. If you don't, then he says, my iPad is an automatic dialer. And the court said, I certainly don't believe that is what the FCC or Congress intended when they made these rules. It just can't be. So they realize that it's gone too far. How are they going to narrow this down? You know, one FCC commenter said, look, we've declared 3 times in 3 different rulings, 2003, 2008, 2012, what is a dialer? And we've told you, so what is there more to declare? We think you need to go to Congress and get this fixed. Well, we are doing that, and the ACA International is actively working on that. Recently, they were able to get the ACA working tremendously with congressmen throughout the U.S., got 15 to sign on to a letter that asked the FCC to seriously look at the ACA's petition for rulemaking to make common sense decisions and rules with respect to dialers in our present arena, in the 2014 arena, in a climate where 60 to 70% of households are now going cell phone only. The FCC gets it. I think they get the issues. They've heard it 100 times. I've been in front of them on several occasions. Others have gone there. The ACA has been in front and center of the FCC and pounding them left and right and having private meetings and meetings as high up the chain within the FCC as they could go. So they're doing what they can do to, you know, rectify these issues. They're just tough issues. Again, there's 40 petitions out there on the dialer, wrong number, and other issues. So the FCC is inundated. It's interesting, though, that the TCPA is only a tiny, tiny, tiny part of what the FCC deals with. They're dealing with telecom and telecommunications issues and cable issues that are beyond what any of us can probably envision here on this phone call. But they understand the pressure on them is mounting. And when you're a commissioner like O'Reilly who makes that public statement and says publicly and to people in private meetings that this statute's crazy, change has to be done, the question is, how broad is the change going to be and when? And if we do get relief and if there are orders issued, are they going to benefit the industry to the extent that we need them? We can only hope. I can tell you I'm fighting the good fight. Many, many others out there are fighting the good fight every single day. The amount of pro bono hours that I give to the collection industry would fill an attorney's entire year. But I'm doing it because I care about the industry. It's critical and it's important. I see what happens on a daily basis. I'm fighting these class certification cases. I fight the individual TCPA actions. I fight the FDCPA class actions. We see what's going on a daily basis. Change needs to be made.
Yeah, I mean, if you look, if I was going to say, if you look at these numbers from the poll, I mean, a third of the people on the call have been targeted by TCPA litigation, and half or 20% know somebody that has been. I mean, they seem to be making the rounds, especially in certain industries. You know, they kind of focus on collections, business-to-business calls, even political, other areas where companies thought they were exempt from TCPA and are taking swipes at them. So,
you know, and that's a very good point. And look, the plaintiffs' counsel know that change is in the air. They understand that. They see the pressure on the FCC. The National Consumer Law Center, they themselves have gone to the FCC and they submitted an ex-parte brief that basically said, look, you know, predictive dialers harm consumers. Calling them on their cell phone harms them without consent. You know, you can't make these changes. You need to use restraint. You need to keep the law as it is. So the other side is fighting as well, but I can tell you it has been far from as vigorous as the entire every industry who's fighting against the TCPA and fighting to make change in it. It's almost like 40-1. But so we don't know what's going to happen. The petitions before the FCC are broad. And they seek, you know, relief. They ask the FCC to really consider what it's doing on the dialer front, to change the rules on dialers to make them realistic for the 20th century because they're so outdated right now, and to give clarity because there's inconsistency throughout virtually every court, and it depends which jurisdiction you're in. And sometimes even within your own jurisdiction, courts within that same jurisdiction are issuing different results. So look, there's ways to fight these cases. There's strategies to fight them, and there are some good defense techniques. And again, you must look at your case carefully, look at the facts, look at what is the best technique in your case for the given, and that's what I do in analyzing every one of these cases. I say, what is the best way to go in this case for this purpose at this time, with this court, with this judge, and these set of facts? And that's where you go from and you litigate it. Again, we're all fighting the good fight. Ryan here is fighting the good fight. Andy at New Star, they're fighting the good fight and coming up with new technology to try to help the industry on as much as they can because they understand the struggle. So with that, everybody, I know we went a little over. I thank you all so much for participating. If there's any questions, I'm willing to stay on for another 10 or 15 minutes if that helps. And certainly I can be reached, in my contact information for those of you who want it is at the end. Please look at my takeaways. My takeaways are a recap of everything that you should be doing to try to help yourself minimize the risks of TCPA liability on the dialer front, on the consent side. So please read all those. I don't need to read them for you. It's in the PowerPoint. You're going to get it. If you have any questions, all of you, you know how to reach me, contact you. I'm probably familiar with many of you on this telephone call, and all I can say is just good luck and keep up the good fight, and thank you for all that you do and all that you struggle with on a daily basis. I am grateful.
David, thank you for an excellent presentation. I think myself included, and as well as other folks, got a lot out of it. That we did have quite a few questions that kind of came up that if you do have a couple minutes, it'd be good to recap and clarify in some of these issues, because it is very confusing trying to break everything down. And so basically what we're going to do is go in there and take a few questions and
Sure.
we're going to get people updated as well on some of the information that's out there as far as the slides, and we'll have a link to the recording. So if you didn't get everything written down that David had, which was quite a bit, we'll be able to at least get you the information in the slide deck, but also we did have it recorded, so we'll get a link to that out to folks as well. So let's kind of go through a couple of these questions. The first one was David mentioned that consent is specific. Can express permission be requested and given for more universal purposes if specifically mentioned as such?
Okay, and I think we touched upon that issue saying, look, do we have consent to call you on your cell phone for any and all purposes? That may give you this broad consent that you're talking about. I don't know in what context you're referring to, so it depends also in the context. But then again, a question like that, so broad, especially with someone who's intelligent, is going to invite questions. So sometimes it's hard to get universal consent. You know, when you're capturing consent in a website, you know, you may have very, very broad consent there. So someone, you know, if you're capturing on a website and they agree to it, then they are deemed to have read the terms and conditions, because they have to check, I agree to the terms and conditions herein. So it depends how far you're going. It depends in what context too. I would probably need to know more specifics.
Next question is, what if the customer willingly provides a cell phone but doesn't have the ability to clearly indicate that it's a cell phone? For example, what if a payment coupon or website allows for phone number updates, but the field is just marked telephone? Can we auto-dial that number for debt collection purposes?
Okay. So you're not sure if it's a cell phone, but you want to know if you can auto-dial it for debt collection purposes. I may have missed part of what you said, Ryan.
It has to do with like a customer update on their information. So what if there's a payment coupon or customer facing site, they go and update their phone number. Does that?
Well, that's a good question. So if someone updates their telephone number on a particular website or a payment coupon under this, it depends in the context of what they gave it. Again, the FCC came out with its amicus brief in NIGRO and said consent is narrow and has to be construed in the context in which it was given. So that's something that you always need to take into account. Yes, a lot of us in the industry, we're all thinking, hey, someone gives consent, we're good to go. We can call them for any reason. You've got to look at the circumstance in which consent was given and, you know, in the context in which it was given. And I use that Walgreens as an example. I know that was oral consent, but she did give oral consent for a specific purpose, but then they called for a different purpose. Yes, you would think that given consent in the context of your prescriptions would allow the company to call you to tell your prescription is ready. I get it. But she's saying that it was specific as to the reasons why Walgreens articulated the reason why they wanted the number in the first place. And that's what I think locked them into that narrow interpretation. So you've got to look in the context in which this updated consent is given. That's key.
And I think that relates to the next question, which was the person, she wanted to know what your position is on making other types of calls, not collections, using a cell phone number provided by an individual. Does this stretch the FCC declaratory ruling?
That's a very good question, because many industry have been using the FCC's 2008 ruling that if you're doing something on behalf of another, that consent stretches there. That FCC ruling really was specific to the debt collection industry, and appears to apply mostly in context with debt collection industry. So if you're calling on behalf of another, the question is, does the FCC ruling stretch to each and every industry? Maybe, maybe not. You have to look at it. I'd have to see the context in which it was doing. It depends. You know, if we're talking about telemarketing, that's a whole different ballgame, and that's for another PowerPoint, and that's for another time. So we'd have to talk about that in that context. But it just depends on the industry that you're talking about. But again, the FCC's 2008 ruling was specific as to the debt collection industry.
Makes sense. Do you have any insight on the estimate of number of cases, TCPA cases to date, post-2012 versus the changeover in October last year? Does it seem like things are ratcheting up? I mean, is it 10 times more? I mean, it seems like it's kind of trickling in, and then it's come up a lot more in the last couple months now that we've had time for that law to sit, plaintiffs to go out there and solicit cases and classes and figure out how
and what Ryan's talking about, he's talking about the October 16, 2013 telemarketing rules, and those rules were implemented. He's saying since those rules were implemented where for telemarketers they have to have prior express written consent, not oral consent. They can only get consent in writing with very specific parameters. Some plaintiffs' counsel have already started suing under that law. So yes, it is starting to ratchet up on the telemarketing side under the new rules, but not as much as I would have expected so far. But it's starting to ratchet up.
So here's a real detailed legal question. It was, does paragraph 5 trump paragraph 13, i.e. debt collection calls are excluded and for all other calls human intervention applies?
I'm sorry, I don't know what paragraph 5 and what paragraph 13 is. Someone talking about the FCC rule, the FCC 2008 ruling?
Yeah, I think that's what they're talking about, because the question came in towards the end, about 20, 30 minutes ago, so towards the end.
I'm sorry, I don't have the FCC 2008 ruling right in front of me this minute, so I can't answer that. But the requester can certainly contact me offline.
Yeah, let's take that one offline. That way we can break that down a little bit. This is the question of what constitutes a dialer. We get a lot of those questions too. Here's what I'm using. What do I need to scrub? Is this considered an ATDS? What do I do with my wireless numbers? So the next question is kind of related in that regards, which is if the dialer system does not dial without human intervention but requires a human to okay the call but does not require the human to key in the number, is that an ATDS?
Very good question, and I wish I could answer it in one fell swoop. I'd have to know more information. I'd have to know more information about the dialer, the system, exactly what the person is doing to be able to comment on that. And again, most of these dialer issues, very few courts and judges are ruling on them themselves. They say, sorry, there's disputed issues of fact between this expert and this expert. I'm going to relegate this question to the jury. So many of the times they won't even make that decision, and you can't get a ruling from a judge directly on whether you do have a dialer or don't have a dialer. They're going to punt it to a jury because they say there's a disputed issue of fact, and that's the two experts battling it out. So, I mean, I would have to know far more information to even begin to comment on that issue.
Do any of these cases actually go to trial, or are they mostly handled in the settlement once they kind of get the damage assessment? Because we've done that for companies that are being targeted for TCPA, where they'll come in and go, all right, here's what we're looking at, or a law firm will contact us, and we'll look at, okay, how much of that is real? How many were cell phone numbers? How many were ported? You know, what is the reality of how many cell phones did you actually call? Is that where you work on a settlement, or, you know, do you go, hey, look, there was really a minor safe harbor deal here, let's fight this case, and it ends up going to trial?
Well, you know, the majority of cases do get settled in the TCPA arena, especially in the class action arena, because in some instances, to fight certain cases with certain companies depending on what and who you are. And again, that's why I said an individual assessment has to be made for who you are, what the case is, what are your facts, what kind of system you're using, et cetera, et cetera, et cetera. Most of the cases are getting settled or resolved because sometimes these are bet the farm cases. I mean, if you're outside potential liability because of the amount of calls you made over a 4-year period is $3 billion, which of course is stupid and academic, I get that. But it means that it's, you know, that the potential liability is extraordinary. You've got to look at everything in a way. Do you fight this case? What is your strategy to get rid of it early? What's your strategy to resolve it earlier outside of the class action context so that you never have to deal with the class? As you can see, many of the bigger players, they're having to settle or deciding if they have to settle their cases on a class basis for numerous reasons. So it all depends, but the majority are getting resolved in the settlement arena.
That's good information just to know, because I think for people that haven't been faced with one of these cases to really understand what's going on, it's a little different than and a lot more to deal with than people understand, especially when they pay $9,000 an hour. Just kidding.
I can trust you. That isn't my rate.
Let's take one last question, and then we're going to sign off, and then we'll get the slides working out to people, which is if we get consent when one number is entered online with language that says we have consent on this number and any other numbers you may provide to us in the future, and the telephone agent obtains another number during a future call, do they have to read and get express consent again, or is the upfront language sufficient?
Repeat that one more time.
So if we get consent when one number is entered online with language that says we have consent on this number and any other numbers you may provide to us in the future, that part's in quotes, and a telephone agent obtains another number during a future call, do they have to read and get express consent again, or is the upfront language sufficient?
I hear what you're saying, that you got the language up front in the credit card application, and that says we can call you at any number you provide to us or may provide in the future. Okay, that contractual language can, of course, help to get you consent there because I think that's pretty clear and unequivocal language. And if someone, A, voluntarily gives you their number in the future to be used in connection with the debt, well, that in itself may be express consent, and you're capturing that in your collection software, your account software, and possibly on a recording, plus they're putting it in writing, I believe that you have prior express consent.
Cool. That was a lengthy one. That one wore me out. I'm done.
Well, I just want to personally, David Kaminski here, thank you to everyone here on the phone call. Again, we're fighting the good fight. We're working hard for you. I'm working hard for this industry because I care about it, and this statute has become crazy and insane, and the scales need to be tipped. We need a level playing field to fight against these plaintiffs and this crazy statute in the way it's being interpreted by the courts and the FCC. And thank you, Ryan, so much for the opportunity. Thank you so much, Andy Stickle with New Star, for sponsoring this event. Greatly appreciated.
Yeah, thanks, David. I think we did a really good job breaking things down, and if there's some questions that we didn't get to, feel free to reach out to us or we'll follow up. And hopefully we'll be able to see you at some of our future events. I'll be at the Washington, D.C. PACE Summit in October, and then we have a compliance event in Florida on December 10th. We're going to do another kind of panel of TCPA experts, and just got to keep things updated and more of a workshop environment. But I think we covered a lot of ground today, and I'm glad we've got some good takeaways for people, and appreciate everyone's time. Thank you very much.
Thank you so much.